So the Ninth Circuit upheld the federal district court injunction against the implementation of Trump's executive order, which temporarily bans travel to individuals from the 7 countries included in that order. A political decision or a legal decision? Before we get to that, just a little reminder, the genesis of the 7 countries that were listed in Trump's executive order. President Obama's Homeland Security Secretary Jay Johnson testifying before the House Homeland Security Committee in July of 2014. Take a listen.
Foreign terrorist travel, the prospect of foreign terrorist travel to our homeland keeps me up at night. Of course, cybersecurity, aviation security, border security, the prospect of what we refer to as special interest aliens arriving on our southern border are things that we should all be focused on and dedicated to addressing. We have enhanced the security around our visa waiver program. With the help of this Congress last year, we now have the ability to deny visa-free travel to those who have traveled to Syria, Sudan, Iraq, Iran, and as a result of the 3 new countries I added to the list because of this new legislative authority, Yemen, Somalia,
5, 6,
and
7.
Libya.
Yep, that's it. Those are the 7. Yeah, he's got them all there listed. And that was Jay Johnson taking credit for what the administration was doing to restrict the travel of individuals from those countries based on the intelligence information that ostensibly was gathered that led him and the Obama administration to that decision. So the Ninth Circuit's decision, the federal district court enjoining Trump and the Trump administration, and then the Ninth Circuit affirming that injunction, was not received happily by President Trump.
We'll see them in court. It's a political decision, and we're going to see them in court, and I look forward to doing it.
So you believe the judges made a political decision?
We have a situation where the security of our country is at stake, and it's a very, very serious situation. So we look forward, as I just said, to seeing them in court.
Sir, do you think this has undercut the early days of your presidency? This is such a core issue.
This is just a decision that came down, but we're going to win the case.
And
he also tweeted, "See you in court.
Right.
The security of our nation is at stake," all in capital letters, exclamation mark.
To his point about it being political, I thought the response from Washington Governor Jay Inslee, who's a Democrat, was really interesting. In response to...
You don't need to remind me that he's a Democrat when you hear what he did.
Well, in response to the tweet that you just mentioned, Governor Inslee said, "Mr. President, we just saw you in court and we beat you." So we beat you. So this is about like politics. You're treating this like a sporting event. It's not about whether the law was properly upheld, the Constitution was properly respected or not. I find that "we beat you" disposition particularly telling. For more on this, let's get some real legal expertise here. We're pleased to be joined again by our friend Alberto Gonzalez, former United States Attorney General, now the Dean of the Belmont University School of Law. Belmont University, Amy, the Bruins.
Oh, that's right.
And he's also the author of the book, True Faith and Allegiance. Attorney General Gonzalez, thanks so much for joining us. Appreciate it.
Good morning. How cold is it there in Chicago?
It's actually not too bad. This global warming thing is starting to work out for us. So it's like 45 degrees.
I always say, I love global warming.
Congratulations.
So what's your legal opinion on the opinion rendered by the Ninth Circuit?
Well, as a lawyer, if I were in the White House advising the president, obviously you prefer to win these kinds of things because there are a lot of political and sort of public relations implications to an adverse decision. But I wouldn't lose sleep over it. It is simply one very early step, and it's one hurdle. And so, there's still a long way to go. The thing I'm curious about, though, the president has said this is about national security and protecting our country. And this is about to give us time to put in place additional vetting with respect to these individual countries. Nothing prevents the president from simply revising the executive order. I mean, I think there may be things that he could do on his own that actually may moot out the case. And these will represent steps forward in protecting our country. And so that there are things that he might be able to do by simply revising the order and protect our country and perhaps move out the case, as I just said. In terms of what's going to actually happen next, I don't know. I don't know what direction he's going to give the Department of Justice, what General Sessions wants to do. But obviously, there's a lot of options that are possible, and we'll just see what happens.
Well, so if you're there, what's your advice and counsel if you were in that position? Because as you're sort of indicating, he could rewrite the order, moot out the case. He could litigate it at the federal district court level where it's been remanded, or he could appeal it to the Supreme Court.
He could do all of that. At the same time that he's in the courts, he could put in place measures that would protect America, which, quite frankly, I think that's the number one priority. And so, as the lawyers are wrestling with these somewhat difficult legal issues, I'm hoping that his policy teams are looking at what can we do to keep America safe. But we already have pretty strong vetting with respect to these countries. Are there additional things that we can do? I'm hopeful that that's what the administration is doing. They're approaching this on two fronts, both the legal fronts in the court, and then also, practically speaking, what is the right policy to further protect America?
So what revisions to the order should be made? Should he include people with green cards, people with student visas? I mean, what could he do differently if he decides to refile or rewrite an executive order?
Well, that would be one thing. That is one of the issues is that, historically, people that are not U.S. persons and that have no ties whatsoever to the United States generally do not. They enjoy less constitutional protections. Historically, that's been true in our courts. The way this order was initially drafted, though, it did affect people who have some kind of legal basis of entry into the United States. And so there are things that he can do, I think, that make the orders more defensible. One of the things I worry about, and I think I've commented on this before, is in advising the president, I would feel better in terms of this order, in defending this order, if we had some serious threats, reported threats of attacks coming from individuals from these countries, or in fact someone from one of these countries had engaged in an attack or participated in an attempted attack. So now they may have that information for whatever reason. They may not want to share it. Maybe it's not the appropriate time to share it. They may be worried about compromising sensitive sources and methods and don't want to talk about that. But if that's the case, there are ways to still win the case. You could assert a state secrets privilege, where the executive asserts a privilege, and the courts have to make a decision as to whether or not to dismiss the case because the national security of our country is so jeopardized that the disclosure of information to win the case, the government would jeopardize national security. And so in that situation, the courts have historically in the past dismissed the case outright. So there are various things that could happen here. It's just hard to predict because I don't know Donald Trump at all. And, of course, we have a new attorney general, and I don't know the other lawyers working on this case. So we'll just have to wait and see what happens, as I said earlier.
It's the state secrets privilege assertion is an interesting idea because one of the legitimate criticisms of the states and the case the Justice Department presented was the failure to include any documentation or evidence relating to the threat posed by these 7 countries. And again, this is not these 7 countries identified by the previous administration, ostensibly based on intelligence. And so you either can provide some of that or, as you say, assert privilege because it's too sensitive to be subject to public scrutiny. That seems to be a legitimate issue. But the problem is, even if you did that, I mean, the Ninth Circuit decision, for example, on the issue of green card holders and segmenting them out explicitly in any order, that this decision potentially extends due process rights beyond green card holders to citizens from other countries, which is really an expansion of consideration for due process rights for non-Americans. And this gets into the question the Trump administration has to face. We're so confident that we're on solid constitutional and legal footing that we didn't think we needed to do any of this. But you read this relatively politicized and open-ended decision, a lot of new ground being plowed here by the Ninth Circuit, and you say, well, maybe we either provide evidence or we take the advice you offered at the outset of trying to make this matter moot by implementation.
Well, clearly there's language in the opinion that is disappointing and somewhat interesting, is the way I would characterize it. And for that reason, as I said at the outset, as a lawyer in the White House or at the Department of Justice, I'm not going to lose a great deal of sleep over this. I mean, I've been involved in very sensitive, controversial cases where, you have a decision at the Court of Appeals level and the Supreme Court just simply flat out disagrees. That happens. And so the fact that the state of Washington beat Donald Trump, as the governor said, doesn't mean that the state of Washington is also going to prevail on the merits here. I think we have a long way to go, but from my perspective, as I've said before, the number one concern, if you're the president, is how do we protect our country? And so even though we may not have been successful here in the Ninth Circuit, that doesn't preclude the White House from exploring other ways to keep us safe.
I mean, I don't want to belabor this decision too much, but I never really used my law degree, so this is my chance.
Oh boy, here we go.
And so I just have to
brace yourself.
I mean, some of the things that the Ninth Circuit did, they essentially said that they would likely consider Trump's campaign statements in determining whether the executive order violated the Establishment Clause of the First Amendment. Talk about opening Pandora's box.
Well, I've said before in other interviews that if I'm a judge, I would have to discount campaign statements. Think about all the political rhetoric that occurs during a campaign, and think of all the campaign promises that never translate into presidential policy. And so, if I were to consider campaign statements, I would certainly have to discount them because of that very reason.
Now, in this 29-page opinion that they wrote, they did point out that the government failed to offer any evidence that anyone from these 7 countries perpetrated an attack in America. Why do you think they left out that key detail? Is it because there's no proof of it happening?
A couple of reasons. One, they may have felt it wouldn't be necessary, that they could prevail without it. 2, they may, for national security reasons, that they might not want to talk about it or get into the details of it. Or 3, they may not have the reason simply may not exist. So those are 3 possible reasons why nothing was put forward here. And so we'll have to wait and see ultimately what the answer is.
Stories about Judge Neil Gorsuch meeting with senators as per his nomination to the Supreme Court, and suggesting that some of Trump's comments about the federal district court judge in this case were troubling to him, demeaning to judges. Clearly, Neil Gorsuch takes the role of the judiciary and his role as a judge very seriously, as he should, as more should, frankly. And so there's no issue with that. But some people have made an issue of, a president criticizing the judiciary, criticizing sitting judges and so forth. This is hardly new, but what's your posture on that issue? Well,
the framers afforded federal judges lifetime tenure precisely to protect them, to provide protection from criticism, give them courage to make controversial decisions, unpopular decisions. My own view is if a judge is adversely affected by criticism, even criticism from the President of the United States, then that person probably should get a new job, quite frankly. However, I think this is an important point, a big however. Criticism of the judiciary, particularly from the president, does call into question the integrity of the judiciary in the minds of the average American. I don't think that's a good thing. I really don't. I think judges, it's a difficult job. 99.9% of judges are not affected by politics as far as I can see and based upon my experience. They're doing the very best they can. And so I don't think criticism of the type that President Trump has offered is helpful. I don't think it's not good for the judiciary, the image of the judiciary. And so I don't think, again, he did himself any favors. I'm not suggesting the Ninth Circuit was motivated in any way by the comments made by President Trump, but he certainly didn't help himself at all with those kind of comments in this case, and just generally with the judiciary. And
your position then would be the same about what President Obama's comments in his 2010 State of the Union address, where he essentially took out after certain members of the Supreme Court for their decision in Citizens United.
Absolutely, because what are they going to do? I mean, they're not going to defend themselves. I just didn't think it was appropriate. And at the end of the day, we have to have respect for the certainly the judiciary, and I don't think the comments by President Trump were helpful. I know that President Bush, and I certainly the kind of statement I would have made was that I respectfully disagree. I disagree strongly, but I respect the decision of the courts, and we plan to appeal. I think that's a much more appropriate way to respond to an adverse decision.
He is former United States Attorney General and now the Dean of the Belmont University School of Law, Alberto Gonzalez. His new book, True Faith and Allegiance. Alberto Gonzalez, thanks so much for joining us. Appreciate it.
Thanks for having me.
And he joined us on our turnkey.pro answer line.